I'd like to call to order the special joint Windsor Town Council, Windsor Water District, and Windsor Redevelopment Successor Agency Study Session Plan. Roll call.
Councilmember Fopoli.
Here.
Councilmember Fudge.
Here.
Councilmember Salmon.
Here.
Vice Mayor Milan.
Here.
And Mayor Okrepke.
Here. Do we have any conflict of interest declarations? Okay, the reason we are holding this as a town meeting, just to let you know, is the fact that we do not want to violate the Brown Act. If we didn't hold it that way, there could only be 2 council members here. This way, by having us a town meeting, there can be 5. So with that being said, I'm going to now turn it over to our facilitator, Jeff Lux.
Thank you, Mr. Mayor. And it's great to see everyone here. Welcome, and thanks for coming. Those of you who are standing, if you want to find chairs, there's a lot of infill opportunities. I see some chairs kind of around. Please come on up and come on up. I see some in front. There's some over on this side, so don't feel like you need to stand in the back, and I suspect we can get more chairs if you need them. My name is Jeff Lux, and I'm just here to try to keep the meeting on track. We have lots of people. We have a lot of people that want to speak. We have a number of speakers and panelists who are also going to speak, and so we want to see if we can efficiently and get everybody an opportunity to ask questions and state your opinions. Let me do a little bit of logistics first and a little bit of sort of framing the agenda, and then we'll get right on with the different speakers. First, restrooms, I think you found them. They're right over here, men's and women's on different sides of the hallway. There's some refreshments in the back. I don't know how long they'll hold out with all of us in this room, but thank you very much for providing them to the town. We will have, if you need it, we will have Spanish translation available if anyone needs it. Hang on just a second.
Buenas tardes, mi nombre es María de la O. Tenemos 3 personas que pueden traducir para las personas que no hablen inglés. Las personas que tenemos aquí es Irene, Lisette y Denise. Gracias.
Okay, thanks. So what I want to do is just to clarify a couple things on kind of how we're going to proceed, quick agenda review, and then we're off and running. The basic objective of the meeting is on the agenda. I think many of you have seen it, but it's important to remember why we're here. Provide an open and transparent forum for all parties, including decision makers, staff, residents, project proponents, and opponents, press, etc., to learn together and have an opportunity to discuss their interests and concerns for the proposed fee to trust application and subsequent projects. So it is a learning session, study session, primary. No big decisions to be made, no votes to be taken, but an opportunity for us all to learn together. A couple things in terms of logistics. There'll be a number of ways in which all of you will get a chance to participate. The first is coming up to these microphones under the public comment and dialogue period. We'll have some time limit. It'll depend on how many people want to speak, but a couple of minutes, and you'll get to say whatever you need to say, and we'll move from microphone to microphone. We also have comment cards that are located on the table in the middle, a table on that side, and a table on that side with magic markers, and you're welcome to fill out your comment card with anything you want to say. This is if you don't feel like coming to the microphone and you want to write it down, or if you have a specific question that you want to pose to one of our speakers, we'd like you to write it down so that we can sort of organize the questions and keep things moving and make sure we're not asking the same question twice. So if you could fill out those cards, that would be wonderful. You can fill them out at any time, sort of pass them to the edges maybe, and we'll have one of, I think Denise is going to go around and kind of collect them from time to time. So that's 2 different ways in which, under public comment and dialogue, you'll get a chance to talk. Lee, my able-bodied assistant over here from UC Davis, wonderful graduate, recent graduate of UC Davis, is going to be trying to keep track of all the comments. You won't be able to see them, but she's going to be writing madly all the things you say and putting your comment cards up on that side eventually as well. There will be notes, of course, from this meeting. One last bit of logistics is Lee's going to pass out some blank sign-up sheets. If you wish to sign your name and put your email to be able to continue to get information and be on a list and be part of the process, we welcome you to do that. You don't have to do it, but if you'd like to, Lee will pass those out and a couple of pens, and you're welcome to do that and just kind of pass them toward the end, and we'll collect it at the end of the meeting. Okay, the last thing I want to do in terms of logistics before agenda review is talk about some meeting protocols. We recognize that this is an unusual meeting. Look at the numbers of people, your friends and neighbors that are around here, lots and lots of us. We also recognize that passions are high on this issue. There's a lot of people who are very concerned about a lot of issues. We understand that. It's been in the papers. There's been a lot of discussion already. As a result, it's important that we sort of follow some protocols to make sure that everybody gets a chance. The first thing we tried to do is make sure that we gave the speakers the same amount of time, those that are in favor of the project or part of the project, those that are opposed to the project. We wanted to make sure that they had an opportunity to give a comprehensive viewpoint. All of you will also get that opportunity, but what I'd like you to do is to follow a couple simple meeting protocols, and they're the kind of protocols that we always use at meetings. There's nothing unusual about them, but they help us basically protect everybody's interests, to keep us on time, make sure that everybody gets a shot, and that everybody's respected. Let me just read them. There are copies of them in the back, a whole bunch of copies, but I decided not to pass them out because I didn't feel like it would really be of much value to pass them out. These are the simple kinds of ground rules or protocols that we all learned in kindergarten. Please be respectful of all participants and speakers and their viewpoints, even if you disagree. One person speak at a time. Please be concise, try to stay on topic. Repeating the same issue or concept multiple times does not necessarily mean it will be more convincing. The facilitator, that's me, will follow the agenda and try to keep everybody at their times. Please try to respect time limits. We have diverse and conflicting interests and opinions. Treat those differences as a strength and an asset, not as something to challenge or be concerned about. It's okay that we have difference of opinion. That's what society and decision-making is all about. Everyone has the opportunity to participate. If there's insufficient time, or if you want to put some things down and don't feel like speaking, that's what the comment cards are for. The scribe will take visual graphic notes, but these aren't the official record of the meeting. An official record is being taken by the town. Please no jeering, cheering, clapping, or other displays of support or objection as speakers come up. First of all, it takes away from our time, and it actually takes a lot of time. Second of all, it could be seen as potentially disrespectful. If you feel the need to, say, yes, we support that view, or, yes, that speaker really spoke for me, maybe a show of hands, quiet show of hands like this might do it. It'll show that you've got lots of people out there interested in the same issues, but cheering and clapping and jeering really isn't going to help us too much. Speak clearly into the microphone, and I'm not doing it as well as I should. You got to have the microphone real close to your face, and these are the 3 microphones we're going to use when we get to public comment. Strive to be understood, but also to understand others' views. This is a time to learn. Please refrain from any disrespectful gestures, name-calling, accusations, anything of that sort. And if you do have specific questions for specific people, for example, one of our speakers or possibly someone from the town, that's what I'd really like you to put on a card and get up to us so that I can sort through those and we can have the town sort through those a little bit so we aren't asking the same question to the same person multiple times over and over again. All right, hopefully we can abide by those simple rules and the meeting will go along and everybody will get their shot. Now, quick agenda review. We're going to spend about 1 hour listening to each of the different perspectives. First, the town of Windsor, Nancy Thorington, who is seated to my right, who is the tribal law counsel for the town. Congressman Huffman, who I understand is arriving, who is just in some difficult traffic, will be next up to talk a little bit about his perspective and the perspective from his office. The county will then follow, and that will be Supervisor James Gore and also Attorney Bruce Goldstein. The Lytton Rancheria of California will then follow, Chairperson Margie Mejia. I was close. Thank you. I did my best. And Larry Stidham, attorney for the Rancheria. Citizens for Windsor will then follow, Brad Whitworth. And then Neighbors of Lytton Development, Linda Hopkins will then follow, and then we will let the town council have some brief comments. They'll have a chance to kind of weigh in and give their thoughts about the process, and then it'll be open to all of you. I may at some point decide to take a break because we're just wearing down and we need a break. I may not. Let's just see how that goes. I'll gauge how much time everyone gets based on how many hands we see in an hour of how many people actually want to come to the microphone and speak, because we do have a lot of people here. We want to give everybody a shot. Okay? All right, that's the basic agenda. I think with that, we are probably ready for the first presentation. And what I'd like to do is, Nancy, I think you're going to come up and use this one, hey? Okay.
Well, welcome, everybody. Again, my name is Nancy Thorington. I am a special counsel for the town of Windsor on federal Indian law issues. And Jeff said that we are having 10 minutes for each panelist. I'm breaking that rule. So I'm going to basically give you federal Indian law 101 in 30 seconds or less. So I'm doing my best, but I want to make sure that we have that background to start with. So with that, the first question is, what is a tribe? We may think that we know what that is just by virtue of it saying, well, we're the Lytton Rancheria. A tribe is a distinct political entity, and we're going to concentrate today on federally recognized. There are also non-federally recognized, but that won't concern us today. Basically, that means that the federal government has acknowledged a government-to-government relationship with this political entity, and tribes engage in government-to-government relationships with all other governments, state, local, other tribes. Okay. Next is tribal sovereignty. So sovereignty is the concept where any political body, it's what they're allowed to do. And that includes basically governing internal and external matters. And for tribes, they also have the ability to determine their own membership. And tribes are very unique in that they are not a state. Their sovereignty predates the United States Constitution, so they're not subject to the Constitution the way a state or the federal government is. So the courts had a really difficult time trying to figure out what they were in the early days of the United States history. And the first articulation of what they were came out of a case from the 1830s. It was coined that they were domestic dependent nations. And so essentially they're not a state. They have different type of sovereignty than a state. More in some areas and less in some others. They're not subject to the Bill of Rights or other aspects of the United States Constitution. Another unique aspect is they are subject to what's called Congress's plenary or complete power. So Congress can recognize tribes, it can enact legislation that de-recognizes them, it can basically say what tribes can and can't do and what their jurisdiction is. Also in these early cases, it came out the doctrine of the federal government's trust relationship with the tribes. And it was originally articulated in some of these early cases where you had, in particular, the state of Georgia and the Cherokee tribe. They were trying to enact or enforce, their laws. The state of Georgia was within Cherokee territory. And so the Supreme Court said, no, you can't do that. The tribe's land is theirs, and they are sovereign in there. And they articulated this trust relationship, which basically sets up what's called a fiduciary relationship between the federal government and the tribes, and that requires the federal government to act in the tribe's best interests. So now we come to one of the results of this trust relationship is trust land. So when you talk about Indian land or Indian country, that means that the federal government has taken that land and put it into federal trust. And most land is held in fee. So if you own your house, that's in fee. When land is put into trust, the federal government holds legal title to that land. So the land is technically federal land, which is why gaming is allowed, because the local laws don't apply in the same way. And in addition, the tribe is the beneficiary. So what that means is that the land is not subject to local taxation or land use regulations, CEQA, which is environmental laws. So moving on into some California Indian history, it's important to note because California has a really unique history with its tribes. What happened, and this is in particular with the Northern California tribes, in the 1850s, right after California became a state, the federal agents came out and negotiated treaties with the tribes, and because at that time they were they were treating the tribes, the same as they would a nation, and they had to engage in this treaty-making process. Like any treaty, they had to be ratified by the Senate. So the senators from California went out to D.C., and in closed session, they convinced their fellow senators not to ratify the treaties, but they didn't tell anybody. So what ended up happening was several tribal groups moved from where they were living to where their reservation was supposed to be. But because the treaties were never ratified, those lands never became Indian land. And what that did was then the tribes who moved there had no right to that land, and they essentially became homeless. And that's really significant in California history because at that time, there were indentured servitude laws on the books. What that meant was any Indian person who was found, quote unquote, to be vagrant, a white person could take them and make them an indentured servant, essentially a slave. So that created a lot of problems, and there were a lot of Native people in California who were enslaved during that time. So to address that, the federal government in the 1920s started establishing these rancherias. You'll hear that term. That's unique to California. They're basically small reservations, small areas of trust land. Okay. So then in the 1950s, under President Eisenhower, the federal government entered into what's called the termination era. So they were trying to kind of put feelers out to see if they could start terminating this relationship between the federal government and the tribe. So they enacted a couple of acts to see how that would work. And one of them that's of particular significance is the Rancheria Act. And what happened in that act was the rancherias that had been established in the 20s, most of them were pretty rural, and they didn't have a lot of services. They didn't have roads. They typically didn't have water or sewer. And so what the federal government did was they said, okay, so if you agree to give up your trust relationship with us and no longer have this status as a tribe, we will provide these services. We will provide housing, we'll provide roads, sewer and water. And so several tribes did that, and the land was taken out of trust, and their federal recognition was terminated, but in the end, none of those services were provided. So what ended up happening was when the land went out of trust, during that time, a lot of it was lost, quite frequently to a tax sale, where if the tribe couldn't afford to pay the taxes, it got taken over and then sold. So in response to that, several Northern California tribes in the 70s and 80s sued the federal government for violation of its trust relationship and for failure to provide the services that they had promised. And many tribes were restored during that time via either the court cases or specific congressional actions. And but because most of the land was lost, it was pretty common that the tribes that were restored were landless. So the Lytton Rancheria was one of those tribes that filed suit, and the case settled. It was the Scotts Valley and I think it was two other tribes, the Lytton, and I'm not sure who else were involved with that. And so when they settled it, the federal government basically acknowledged that the tribe was never terminated. They restored the tribe to their federal recognition, and they relisted them on the Federal Register. But one of the unique things about the Lytton Rancheria lawsuit was that the county of Sonoma intervened, which was not typical in these cases. The tribe's original land was in the Alexander Valley, and in the interim when the land was lost, it got purchased by, well, pretty much the way it is now with Windsor. So they didn't want to lose that land, so they negotiated into the lawsuit settlement some restrictions on how that land could be used. First, with respect to the land that was in the exterior boundaries of the former reservation, the land uses had to be consistent with the Sonoma County General Plan. Second, the tribe agreed not to reestablish its former boundaries in its prior reservation. And with respect to the lands in the entire Alexander Valley, which there's a map that was attached to the settlement that explains what the Alexander Valley constitutes. None of that land could be used for gaming unless gaming was authorized under the county's general plan. And in exchange for that, the county agreed to help the tribe to find some land for housing and economic development. So I wanted to also touch on another piece of federal legislation that came out of this termination era because it applies to California tribes, and it's called Public Law, or PL 280. Basically, tribes were under federal jurisdiction for criminal jurisdiction for major crimes, things like murder, and they had concurrent or, at the same time, jurisdiction with the tribes on lesser criminal offenses. So what Public Law 280 did was it transferred all of that federal criminal jurisdiction from the federal government to the state of California. There were about six other states where PL 280 was effective and still is today. For example, Oregon, Washington, Alaska. They were kind of like the test cases to see whether this policy would work, which didn't really work very well, because what they did was they transferred the jurisdiction from the federal government to the state, but they didn't give the state any money to engage in that enforcement. But that's the way the law is today. So right now in California, in Indian country, the state, which basically goes down through the sheriff's department, has criminal jurisdiction on tribal lands. It does not, however, have what they call civil regulatory jurisdiction for Indians in Indian country. So the state, what they call criminal prohibitory laws apply in Indian country in California, but the civil laws do not. So for example, state and local tax laws don't apply, labor laws don't apply, environmental laws, although federal laws do apply, and then the local land use laws. Another important aspect of tribal sovereignty in California to note is that, again, city and county jurisdiction, there is no city or county jurisdiction at all in Indian country. Another important concept is tribal sovereign immunity. All sovereigns have some level of immunity, and it's usually spelled out in statute. The court cases have come down, in particular, when it comes to tribal sovereignty, to say that the sovereignty can only be waived, which how that comes out is a tribe can only be sued, for example, if the waiver of sovereign immunity is expressed. So it either has to be expressed in a federal statute or the tribe itself has to agree to relinquish its sovereign immunity. So on to the fee to trust process. So like I said, most land that you get when you buy it, it's in fee. To get it from the fee status to the trust status requires a congressional action. The two main ways that that happens is either through what's called the Indian Reorganization Act of 1934, or the IRA, or through some special legislation. I'll start first with the IRA. It says it gives the Secretary of the Department of the Interior authorization at his discretion, a little sexist there, to acquire any interest in lands for the purpose of providing land for Indians. And there are several requirements that have to be met for that to occur. First, one of these three things has to be there. The property either has to be located within an existing reservation or adjacent to it. The tribe has to already own the land, or the acquisition has to be necessary for tribal self-determination and economic development or housing. That last piece is really pretty easy to meet. Pretty much any time the federal government's going to take land into trust, it is going to be for the necessary for tribal self-determination. So that's not really a hard standard to meet. In addition, the Bureau of Indian Affairs, or the BIA, they're the ones that are, that's the federal agency in the Department of the Interior that that does these administrative deed of trust applications. There has to be statutory authority for the acquisition, which is the IRA. There has to be a need of the tribe for the land. There has to be they have to spell out what the proposed use is, and they have to address the impacts of putting the land from fee to trust on the local governments and its land use laws. Then sorry, I don't have any control over that. Okay, so there are copies of it too, yeah, so hopefully, okay. I don't know. I can't tell anyway, I can't see, so. So in addition, the other factors that the Bureau has to consider are the jurisdictional issues and conflicts of the land use with the surrounding properties. The ability of the BIA to discharge the trust obligation, I have no idea what that means, and I don't think the Bureau does either. The sufficiency of the NEPA, which is the federal version of CEQA, the Environmental Policy Act documentation, the location of the land, that in some cases that is really an issue. Some tribes try to get land that's pretty far away from their traditional homeland, and the Bureau will definitely question that. And then the anticipated economic benefits to the tribe of putting the land into trust. So the process is pretty straightforward. The tribe fills out, well, I say it's straightforward, I don't have to fill out the application, but the tribe fills out an application to transfer the land from fee to trust, and they submit it to the Bureau of Indian Affairs. Then the Bureau takes that, and then they start reviewing it, and then the tribe prepares an environmental assessment document to see what the environmental impacts of putting that land into trust would be. Then the Bureau takes all that documentation, and then they put it out for public comment. So like in the Lytton fee to trust process, the town and the county and several individuals probably out in the audience made comments on the environmental documents. And so then the Bureau takes all those in, and then they look at them, and then they make a decision whether to put the land into trust or not. Once they make that decision, they put it out, and any interested party, which is pretty much anybody, has 30 days to appeal that decision. Now, it's important to note that this isn't just unique to the Bureau of Indian Affairs and fee to trust applications, but generally with administrative decisions, which is what this is, the courts give what they call great deference, or leeway to what the Bureau determines. So if whichever way they decide, whether they decide to put the land into trust or not, the courts will, unless the Bureau has applied the factors, way out of the bounds of what's, proper, they will give deference to what the Bureau has done. So I'm going to go over this. There was a recent, fairly recent, 2009 Supreme Court decision. It's one of the few that's ever come out that discusses the this fee to trust process under the Indian Reorganization Act. So it's important to look at the language because it hinges on this language. Well, let me give you a little background. This was the Narragansett tribe in Rhode Island. They were not a federally recognized tribe. They were a state recognized tribe. And in the 80s, they finally became federally recognized and then submitted an application for a fee to trust under the IRA. And the Bureau accepted that, and the state and I think it was the county challenged that. So the court was looking at the language in the IRA, and here's the operative language. So the Secretary is allowed to take land into trust, quote, for the purpose of providing land for Indians. And what this case turned on was the definition of Indian, which is all persons of Indian descent who are members of any recognized Indian tribe now under federal jurisdiction. So the crucial word was now. When was now? Was now in 1934 when the IRA was enacted, or was now when the Bureau was taking the land into trust? So the Bureau had been, for 75 years, interpreting the term now to mean at the date they were putting the land into trust. But the Supreme Court disagreed with that interpretation, and they held that the tribe must have been, quote, under federal jurisdiction in 1934 when the IRA was enacted. So, I've got just a couple slides left. Yeah. So, the key to this decision, though, is that in 1934, there was no federal register that listed federally recognized tribes. It was on an ad hoc basis, on a case-by-case basis, and there was no set criteria. It wasn't until 1978 that the Federal Register process was created. So the question is, what is a federally recognized tribe as of 1934? So it's not clear how that's supposed to be applied. And since the Carcieri decision, the Solicitor General came out with an opinion in 2014 that gave what it called, it has a two-part test for determining that, and it's a pretty loose standard for what under federal jurisdiction means. Just to give you, to put it into context, since Carcieri in 2009, the Bureau, to my knowledge, hasn't rejected a single fee to trust application based on Carcieri. So, just the last couple of slides. So, the other way to get land into trust is via special legislation. The key thing to note on this is that the Carcieri restrictions don't apply when it's taken in via special legislation, because Carcieri only applies to the Indian Reorganization Act. So, what controls, instead of the IRA language, is the language of the special legislation itself and any restrictions on that may be included in that. So if the language says the land shall be taken into trust or the land is taken into trust, then it's a mandatory act. There's no discretion for the Bureau, and therefore the NEPA environmental review will not apply. I'm just going to go really briefly over this slide because the Congressman is here to discuss it. So the pending legislation, which is the Lytton Rancheria Homelands Act, basically says that the land, I thought we were going to have maps, so we'll probably do somewhere. Anyway, that the land that's on that exhibit, which is basically the 124 acres that was part of the original fee to trust application, plus 376 later required acres is hereby taken into trust for the benefit of the tribe. It does prohibit the lands from being used for gaming forever. So that's something that the fee to trust application under the IRA that's pending right now doesn't have that restriction. And it also says that the memorandum of agreement with the county isn't subject to review by the Secretary of the Department of the Interior. And typically, any agreements that would bind Indian land for 7 years or more would typically be subject to those restrictions, or Bureau of Indian Affairs review. So this is the last one. I just put it up here. The current status of the fee to trust application. It's already gone through its NEPA review. It does not include the newly acquired 376 acres. There's no restrictions on future use of gaming, and there's no, I don't mean to say there's no mitigation for water, but there was no required mitigation. The tribe did put in some mitigation for that. So with that, thank you for listening to this long presentation.
Thank you, Nancy. Okay. First of all, there are lots of people standing, and I'm feeling like that's going to be potentially a problem. Could I see a show of hands of where there are open chairs? I see two. And if you've got a chair next to you, could you please put your hand up and keep it up for a moment? People who are standing, who are going to get tired and hot, see those hands. We've at least got, there's a half a dozen or so. Please go ahead and grab those. Is there any way we can get any other chairs? Can anyone, do we have any possibility for some more chairs? That would be really good. Okay. Thank you for those raising your hand. We'll see if we can scrounge up a few more places to sit. Thank you for hanging in there. Okay. Congressman Huffman, one quick logistic thing. Are there any question or comment cards that are kind of ready to go? Okay, seeing none, so Denise doesn't need to pick any up. Okay.
Is that my cue, Jeff? Terrific. Thank you. Good evening, everyone. Can you hear me okay, or do I need to hold the microphone closer? Okay. Yeah. All right. Well, thank you. I want to thank the town of Windsor for accommodating my schedule, and I want to thank my fellow panelists and participants up in the front of the room. I also want to thank, well,